Pleasant day to you, ma'am. I'm Ramel Cañete, and for today I'm going to report the Chapter 5 in Legal Aspects, which entitled Law on Sales, Agency, and Credit Transactions. Agents shall ideally work for the best interest of the client. Because of the trust given them, agents initiate actions, administer, and collect on behalf of the client. This is by Elizabeth Wintranon. The objectives of this chapter is to describe and explain the nature of sales and transactions. The second objective is to identify the functions and operations of agencies, and lastly, identify ways of handling credit transactions. Next is the characteristics of a contract sale. First is consensual. Consensual is a contract of sale is perfected by mere consent. No form is prescribed for the perfection in a contract of sale except in the following instances. First is those covered under the statute of frauds which must appear in writing, otherwise the sale is considered unforeseeable. Sale of real property or any interest therein, and sale of chattels or goods for a price not less than 500. B is a sale of property made through an agent, in which case the agent's authority must be in writing. Otherwise, the agency and sale made through an agent is void. Second is bilateral. Bilateral because it gives rise to reciprocal obligations. Third is principal. Principal because it can stand by itself without need of another contract. Fourth, onerous. Onerous because the consideration for each party is the delivery of the thing or the payment of the price. 5 is commutative. Commutative because what the vendor or the seller delivers is considered equivalent of the price paid by the vendee or the buyer. Sixth is nominate. Nominate because it has designated name under the Civil Code of the Philippines, which is sale. 7 is transmissive. Transmissive of ownership because the vendor transfers ownership of the subject matter to the vendee. Effects of loss of the object in a contract sale. In Article 1480, any injury to or benefit from the thing sold after the contract has been perfected from the moment of the perfection of the contract to the time of delivery shall be governed by articles in 1262. Article 1262 and obligations which consist in the delivery of a determinate things shall be extinguished if it should be lost or destroyed without the fault of the debtor, and because he has incurred in delay. In Article 1496, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him, in any manner of ways specified in articles, or in any other manner signifying an agreement that the possession is transferred from the vendor to the vendee. So if the thing is lost before perfection of the contract is considered inexistent. Therefore, the loss is borne by the seller based on the principle of res spirit domino. It is the owner of the thing who bears the consequences of the loss. If the thing is lost at the time of the perfection of the contract shall be considered without any effect. The legal effect is the same as the object is lost before perfection of the contract of the sale. If the thing is lost after delivery, the buyer bears the risk of loss since delivery transfers ownership following the principles of res spirit domino. Sale of personal property payable in installments. It is possible that in buying personal properties used for public transportation or delivery of goods, examples buses, cruise ships, and delivery trucks, these provisions will be useful for the contracting parties in case of the sale of personal properties payable in installments. In Article 1484, In a contract of sale of personal property, the price of which is payable in installments, the vendor may exercise any of the following remedies. First is exact fulfillment of the obligation should the vendee fail to pay. Second is cancel the sale. Should the vendee's failure to pay the cover two or more installments. Foreclose the chattel mortgage on the thing sold if one has been constituted. Should the vendee's failure to pay cover two or more installments. Pacto de retro sale or the conventional redemption. In Article 1601, conventional redemption shall take place when the vendor reserves the right to repurchase the thing sold, with the obligation to comply with the provisions of Article 1616 and other stipulations which may have been agreed upon. As an absolute sale and a sale with the right to repurchase, no difference exists except that in the latter, the ownership of the purchaser is subject to the resolutory condition that the vendor exercises his right to repurchase within the time that is agreed upon. Obligation of the vendee. In Article 1582, the vendee is bound to accept delivery and pay the price of the thing sold at the time and place stipulated in the contract. Actions for breach of contract of sale. Extrajudicial remedies. First, of the buyer. A. The buyer need to pay unless there is delivery. The buyer may reject improper deliveries and the buyer may suspend payment if he is distributed in the position of ownership or thing of the thing or has reasonable grounds to fear such disturbances of the seller. Vendor is not bound to deliver the thing sold if the vendee has not been paid the price. Judicial remedies. Judicial remedies of the buyer, damages for breach of contract, damages for the breach of the seller, recovery of the price, damages in the case of bad faith. Liability of the principal and the agent. In Article 1883, if an agent acts in his own name, the principal has no right of action against the persons with whom the agent has contracted. Neither have such persons against the principal. In such case, the agent is the one directly bound in favor of the person with whom he has contracted, as the transaction were his own, except the contract involved things belonging to the principal. When an agent transacts business in his own name, it shall be necessary for him to state the name of the principal, and he shall be directly liable as if the business were for his own account to the persons with whom he transacts the same. Moreover, an agent is personally liable for acts beyond the scope of his authority and for acts in violation of the terms of the written authority. Simple loan or mutuum. In Article 1956, no interest shall be due unless it has been expressly stipulated in writing. In a contract of loan, if a particular rate of interest has been expressly stipulated by the parties, such stipulated interest shall be applied. If the exact rate of interest is not mentioned, the legal rate shall be payable, which is 12% per annum under Section 1 of the Usury Law. It is only in contracts of loan with or without security that the interest may be stipulated and demanded. And that would be all for the chapter 5. Thank you.